Thank you for joining us for day 3 of our branches of the government. Today we'll close with the Judicial Branch. Once again, we have our lovely trio who will share their knowledge about the branch with you all. The chat feature is open. If you have any questions or want to add to, just type in the chat feature, or if you are able to, unmute yourself and chime in. So I think if I am correct, we had back-to-back days where Professor Powers kicked it off. So are we in agreement that today Professor Powers kick it off again?
I don't want to make him, you don't have to go first again, Professor.
I prepared a board just in case.
Well, then you're more prepared than me in that regard. I have no visuals, but I did feel bad. I was thinking about it last night, and I thought it is unfair that you've had to go first.
You guys feel free to go ahead if you like to. It makes no matter to me. Whatever.
Well, I'm happy to let you do it, but I'm just saying if you prefer not to, I'm happy to go first.
Doesn't matter. Whatever you want to do.
Okay. I'll just say real quickly then, because you have gone first twice. I don't want to make you do it again.
Thanks.
And I'll show you why I wanted you to go first, because I still think you're better at this than I am. But the judicial branch is interesting. It's an unelected branch of the government, designed by the founders to not be as political as the other two branches. Hence the whole need for a lifetime appointment. That way you can go by what the Constitution says and the rule of law. You don't have to worry about things like making sure that your constituents are happy. That does not mean that judges are not political sometimes in their interpretation of the law. I think at various points in history, the bench has been a little more political than others. It kind of ebbs and flows. But it's unique in that way. One thing that I want to get into today, actually, I think is kind of interesting, is the whole idea of a lifetime appointment. The life expectancy of a human being is about 35 years longer now than it was at the time of the founding. So what it means to have a lifetime appointment is a little different now than what it used to be. And that's, I think, kind of an interesting point. If you used to pick somebody who was 45, back in 1790, they might only be on the bench for 10, 12 years. It's a little different now. But it is an interesting and co-equal branch. To me, one of my favorite things to read about the court is Federalist 78. And in there, I think that's Hamilton actually that wrote 78, if I'm not mistaken. I don't think it's Madison. I'm not sure off the top of my head, but I think it actually is Hamilton. But in Federalist 78, the whole idea is discussed about basically the court being a referee, and when there's disputes between both the Congress and the president, or even the federal government and the states, they will just, as judges like to say now, call balls and strikes, to use a sports metaphor, but just decide simply what the rule of law should be, or what the law says, and to interpret those laws. So I now, you have Professor Powers, a nice little chart behind you.
Should have never done that.
You've never made a chart? You are sitting in front of it, so I can't actually see.
Yeah.
I know what it says, but do you want to go? I introduced the idea, but oh yeah, there we go. So the U.S. district courts, there's 94 of them. This is what that, I assume what you wanted to say on that, Steve, is that there's courts you can go in. You start at the lower courts, and you work your way up to eventually get to the Supreme Court. So there's 94 lower courts. If you're not happy with your ruling there, you can appeal to the circuit court if they decide to take the case. If you're not happy with that ruling, you can decide to take the case to the U.S. Supreme Court, and there's where it stops. There's nowhere to take it if it dies at the Supreme Court, as Al Gore can tell you.
Well, I can say a little bit more, which is that a lot of people appeal to the Supreme Court, but generally speaking, they only take about 100 cases a year. So this attitude that, oh, well, I'll just go ahead and appeal this all the way to the Supreme Court, it's similar to buying a lottery ticket. You know, you're probably not going to have your appeal granted. And they pick and choose the cases that they feel are most sort of emblematic of constitutional issues and issues that haven't been fully resolved by the lower courts. And so one of the major issues that's coming up that they've decided to take on as one of the cases is a case on the ACA, which I believe is supposed to happen on November 10th.
That's the Affordable Care Act, for those who don't know, also called Obamacare. Sorry. And
so they could very well overturn Obamacare, regardless of who wins the election. Of course, there are currently 9 members of the Supreme Court. Historically speaking, there has not always been 9 members of the Supreme Court. We've had 6 or 7 at various different times in our history. Over the course of I believe starting in the 20th century, it's been pretty regularly 9 members, and that's sort of the agreed upon tradition. As we spoke about previously in the other class, a lot of the practices which are accepted by most of America are not necessarily explicitly written into the Constitution. So there's nothing in the Constitution that says that the Supreme Court should be 9 members. It's just become an acceptable practice. And so there's a difference between constitutional laws and norms. And the 9-member court is an acceptable norm of behavior. A norm is just something that's considered to be appropriate. And so over time, we've considered 9 members to be appropriate. And of course, when Justice Ginsburg died, she was replaced 2 days ago by Amy Coney Barrett. The way in which you bring new members into the Supreme Court is the president appoints those new members, and the Senate advises and finally gives consent. The way in which they do that is through the Judiciary Committee. In the last session, we talked about how committees have a great deal of power in the political process in the legislature. And of course, the Judiciary Committee is headed by Lindsey Graham, who's the chair of the Judiciary Committee. And so he's the one who presides over the questioning of the appointed member, and that was the questioning of Amy Coney Barrett. And so you ask questions of the appointed member, and then you take a vote within the committee, and then you bring it to the floor, and then the floor votes on that decision. The House of Representatives doesn't have any say over the process of appointing a member of the Supreme Court. And so that's some of the mechanics of it.
I don't have too much to add to all that. I guess one of the things that I'd point out is that, court systems in the United States, and of course our focus in this series is at the federal level, the national government and the judiciary at that level, but there's a federal judiciary, and that's what we're discussing now, but each state has its own set of state courts. So, one of the important distinctions regarding the courts in our country is that federal courts, which are those 94 U.S. district courts, those 13 United States circuit courts, the 1 United States Supreme Court, they only hear federal cases, or what we call federal questions. So the case has to involve an issue of federal law, which would be a law passed by Congress, or perhaps a question arising under the United States Constitution or a United States treaty. If it's a matter of state or local law, that's going to be held at the state or local level by state or municipal courts. So with regards to jurisdiction there, the other thing, Dr. Kupfer noted, cases start at the lower level and U.S. district courts. If you were charged with a federal crime, the U.S. district courts are trial courts. So your trial would be conducted in one of those 94 federal district courts in the district wherein your crime was purportedly committed. think of the country as being carved up in 94 districts, because that's exactly the way that it is. And let's say that you're found guilty there. We've been talking a lot about a balanced system and checks and balances. And remember, when we talked about Congress, we noted that when you open the door to Congress, there's a mini system of separated powers and checks and balances there between the House and Senate. But the court system has an embedded system of checks and balances as well. You know, you can appeal a case to one of those U.S. circuit courts. Again, there are 13 of them. Each heads up a circuit or a geographic region of the country. So think of the country as being carved up into 12 regions. The U.S. Circuit Court for our region is the 11th Circuit Court. It's in Atlanta, and it hears appeals from all U.S. District Court cases heard in Georgia, Florida, and Alabama. And one of the other important things to note is, you know, a lot of times I think students think that the job of a court of appeal is to review whether or not the jury got the verdict correct. And that's not technically true. What courts of appeal do is they look at procedure. They made sure the correct procedures were followed. They made sure that the rights of the criminal defendant, their constitutionally protected rights, their legal rights were upheld. So when guilty verdicts are overturned by a court of appeal, that court of appeal is saying that the procedure used to reach that guilty verdict was in error. They're not saying the suspect was innocent. They're not saying the suspect was guilty, and it's why cases overturned on appeal don't fall under the protection of the double jeopardy clause. You know, you may know that you cannot be retried for the same offense. It only applies if you're found innocent. You're found guilty and your guilty verdict is overturned on appeal. You've not been declared innocent. They're just overturning your appeal on a procedural basis, or perhaps an error in the reading or application of the law. And so, you know, that's kind of important. So what these appellate courts are doing is they're checking to make sure that during your trial, during in those 94 district courts, U.S. district courts, that correct procedures are being followed, that all your constitutional protections, right, an impartial jury, your right to due process, that all of these things are followed. So I find it also interesting that, you know, we, in addition to the broad separation of powers and checks and balances, we have these many checks and balances, certainly within the congressional and the judicial branches as well, which I think is also kind of important. And I just add one last thing. Dr. Kupfer correctly, I think, and very well noted that the judicial branch is, you know, the least democratic of the three branches. Its members are appointed by the president, confirmed by the Senate. They serve lifetime tenure. They're not elected. So they're less accountable to the people. And that can be both a blessing and a curse. The blessing is courts are often the great protectors of minority rights, because the majority will typically push its will through an elected institution like Congress, but what the majority wants may be damaging to the rights or interests of minorities. By having unelected judges, they can go against the will of the majority and not risk losing their position in government. And I think a very important role that courts play in our system is that this is kind of the great protector of minority interests, which are usually, you know, not heard in elected branches like the legislature or the executive. Now that's also, you know, I call the curse part, but that's also created a lot of dispute, because some people believe that when courts to actively overturn something passed by an elected body like Congress, this is damaging to democracy. You have unelected judges second guessing the decisions of government officials who were chosen by the people. So we've kind of talked about this a couple of times now. I think it's an interesting question. You know, how much of our system should be democratic? We go with the majority will. And how much, and I've been using the term, how much should we stress that we're a republic? Yes, we have majority will, but it's tempered by legal protection of minority rights. There's a limit to how far the majority can use its numeric superiority. And no institution goes further in ensuring that than the courts. And in parts because the way they're set up, because they are unelected, because they do have lifetime tenure. So if we were to take that away, even if we gave them a lengthier term, all of a sudden now they have to ponder the decisions they make with regard to how well that will play with the electorate. And that moves them more toward a political institution as opposed to an institution of justice, you might say. That makes sense.
So just to kind of push back a little bit, theoretically, the courts should protect minority rights, but that doesn't necessarily mean that that has always been the case. Particularly the Taney court in particular was very, what's the best way of saying? Just, I won't put lipstick on a pig, I'll just say it was a racist court.
Right.
And it put forth the Dred Scott decision that said that if slaves ran away from these slave states and went to a free state, that they had to be returned by the states, the free states, to their masters. And so this was a very racist decision. And Taney generally, it's the best way of saying, and the Taney court was dominated by Taney, and he was making a lot of the decisions, and he was very much a racist, and said that there were quotes by him that said blacks do not have any rights that need to be respected, or something along those lines. So even after the Civil War, he was still pretty dominant in the courts. And so of course, the supposedly radical Republicans who were very protective of black rights passed the 14th and 15th Amendment, the 14th Amendment giving due process to everybody in the country, even vis-a-vis the states. And then the 15th Amendment giving voting rights to black men. That was passed, but it wasn't really respected in the court decisions under the Taney court after the Civil War. And so it came to be that due process was much more respected for corporations than it was for black people. So
yeah, Dred Scott easily the first decision in U.S. court history. But I think in recent decades that the role the court has come to play is more of one where this is somewhere where if you're not part of a majority faction, you can take a suit to court. I guess what I'm saying is you don't need majoritarian numbers necessarily to prevail in a court of law. That's necessary to win an election. And so I think structurally speaking, the Taney court notwithstanding, I think in terms of structure, one of the reasons that they made the court more detached from the people is to kind of separate the court from the politics. But as you said, best intentions, it doesn't always work out. It matters who sits in the court. It matters who sits in the White House. Point well taken.
Yeah, there's no perfect system. I mean, I don't necessarily think that that's the fault of the court per se. I mean, human beings are imperfect, and so our institutions are going to be imperfect.
I do know that the Supreme Court expects lower courts to do is to uphold its precedents. So if lower courts, openly disavow a Supreme Court precedent, that's going to get their attention. And so I don't know if they communicate directly, but they communicate indirectly, oftentimes by remanding cases back to courts and correcting things. Or sometimes if you read the opinions of the justices, they'll sternly criticize a lower court that has blatantly disregarded a precedent set by the court. I'm sorry, Brian, I didn't mean to cut you off there, buddy.
No, you more or less said what I was going to say. I mean, when decisions are reached, courts will give opinions, and you'll have the majority opinion, the concurring opinion, and then you'll have the minority or dissenting opinion. And what you'll find is sometimes there's more than one. So they write down their rationale for why they're ruling the way they rule. For my understanding is, either of you correct me if I'm wrong, my understanding is for two reasons. One is in the case of lower courts, in case the upper court does take up the case, they know what the rationales were, both pro and con, but also so the public, for transparency purposes, knows what they were thinking and why they ruled the way they ruled. That way it's not just some arbitrary, yeah, you know what? I'm going to go with this. Why? None of your business, right? I mean, they give very detailed, I dare I even almost say in some cases philosophic rationale for why they ruled the way they ruled. Justice Scalia, who passed away 4.5 years ago, who I had there were some cases that I really strongly disagreed with him, but I always enjoyed reading his dissenting opinions. They were very thoughtfully written, and you could really see very clearly why he thought the way he thought, and he walked you down all the different reasons for why he ruled the way that he ruled, when he both won and lost. And so I thought that was it was actually very interesting, because him and Justice Ginsburg, who passed away last month, whose seat Barrett just took, were very good friends, and partially because they loved reading each other's opinions. So you can really read a lot about why they ruled the way that they ruled. And sometimes you'll find there's like 4 or 5 different judges will write concurring opinions that they agreed with each other, but for different reasons, which are also very interesting. So in that regard, there's a lot of communication between not only the courts themselves, but also the public.
And just to sort of bring in something else that is transparent about the court is you can hear the questionings of the lawyers who are representing the cases from the Supreme Court. And it's fascinating. You know, they ask all sorts of hypothetical questions. They dig into the law. And it's a very sort of rapid fire questioning that takes place where generally you'll have 5 or 6, rapid fire questions all on the same topic. And then it can go on for hours. And if you're a law student, you're going to want to listen to these, and they're on YouTube, a lot of them. So you can see. The newer ones. Yeah, some of the newer ones. Obviously,
decision, that's.
Yeah, the Brown versus the Board of Education decision is not on YouTube, but the newer ones are all on YouTube.
We don't have video in the court.
Right.
Yeah, they're all audio. That's an interesting question in of itself. There are those who think there should be videos allowed, but you'll never see court rulings court hearings on C-SPAN. You still get the sketch drawings, things like that.
Yeah, it's made attending the Supreme Court in person kind of a hot ticket, and I don't know. It's been a while since I heard this, and I haven't been to DC in a while. But what I understand is, you used to have to kind of wait in line and then sit all day and listen to the court. Apparently, they've Disneyized it somewhat. Apparently, there's a fast track seat where you can go in and they have an area where you can watch the court for about 20 minutes, and then they'll escort you out, I guess, in between cases. I'm not sure. And then they'll bring in another group of people. So that they're trying to do that.
They do that in House of Commons, or at least they used to.
Yeah, do they? Okay, interesting.
Oh, they
You probably stole it from them there. Yeah.
Maybe. Or vice versa. Who knows? That's interesting. Yeah, they're really interesting, because they do. I think the judge, if I understand, justices, if we understand them as they understand themselves, I do think of themselves as being kind of philosophic, wise people above the fray that can look down kind of on how the government is functioning, and really kind of, the way I always see it is kind of being a voice between the founders perhaps and modern society, kind of, balancing the two. And some would argue, you have some who think that you need to really interpret the Constitution. There's some who are strict, more strict, sort of like instructionalists. I just completely originalist, thank you. That think you really need to go to the letter of the Constitution, and you can't apply different modern standards. But I think that's really kind of, to me, been always a very interesting thing about the court. And actually, and not to undersell some of the lower courts, some circuit rulings are really, really fascinating to read. And those are the people who generally get the job to be on the Supreme Court afterwards. So not only are you seeing kind of the lower bench for people who are going to get called up to eventually become Supreme Court judges, but also you get some really brilliant legal opinions.
Yeah, and we, I think, neglect circuit court opinions, especially on constitutional law and matters like that, at our own peril, because as we've talked about, those are usually the final decisions. That's usually, right, that's usually where the case is going to end. That's going to be the final decision. So we're very keyed in on how the Supreme Court interprets the Constitution or federal law. But in actuality, you know, a lot of these cases end at the circuit court level, and their ruling, their interpretation of the law becomes the precedent, right, at that point.
Okay, we do have a question from a student. If you can, there you go.
All right, I think I can. All right, so my question is in regards to partisanship in the Supreme Court. I know by myth and legend that it's the high and mighty court that is completely unbiased and, you know, faithful to the letter of the law. But the importance has been coming up about, you know, stacking the courts and the potential problems with having a 6-3 majority of conservative versus liberal. How does that play out in reality?
So can I take that one on?
Yeah, I just want to say real quickly, the answer to that is we don't know partially until we know who wins the election, but I yield.
I just wanted to, you know, I'm kind of working my way around to the answer to that question, but I wanted to sort of fill people in on exactly what the 6-3 court is. There are 6 members that have been appointed by Republican presidents. Justice Thomas was appointed by George H.W. Bush. Justice Roberts was appointed by George W. Bush. Justice Alito was appointed by George W. Bush. Justice Kavanaugh was recently appointed by Trump, and Justice Gorsuch was appointed also by Trump, and then Amy Coney Barrett. So those are the 6 conservative members. And then you have Justice Breyer that was appointed by Bill Clinton, Justice Kagan by Barack Obama, and then finally Justice Sotomayor that was appointed by Barack Obama. And so currently right now we have 3 judges that were appointed by Democratic presidents and 6 judges that were appointed by Republican presidents. And so the question is how is that going to affect the court? Now, one of the sort of caveats that I have for that is that most decisions that come down to the court, come down from the court, are either a supermajority or even a unanimous decision. But some of the more controversial decisions that come down from the court are 5-4 decisions or 6-3 decisions. Now, the court is going to hear a case on the ACA as to whether it is constitutional or not. And so that is ultimately going to decide whether the ACA continues, or they might decide that some parts of the ACA are unconstitutional and other parts are constitutional. They can make that decision, but this is going to be very interesting to watch, and it's going to happen well before either Trump has a second inaugural or Biden has an inaugural. And so in the last decision on the ACA, Justice Roberts wrote the minority opinion saying that ACA was constitutional. Then he went to sleep, and legend has it that he woke up in the middle of the night and he wrote the majority decision as well as to why the ACA was constitutional. So he was operating as the swing vote, and it was a 5-4 decision, which decided that ACA could continue. Now, given that Amy Coney Barrett is now going to be on the court, I think that the chances of striking down Obamacare are very high, actually. And so that's a major decision.
I'm sorry to interrupt you, Dr. Lewis, to say real quickly, though, on that, they may also decide the election. Right? I mean, the Bush, in 2000, the Supreme Court ultimately determined the outcome of the election in the Bush versus Gore case. And so you're saying they not only may they make these decisions before the next president's inauguration, they may have a ruling as to who that person actually is. I apologize for interrupting you. I just wanted to point that out.
And just to piggyback on what Dr. Kupfer is saying is that Trump appointed Amy Coney Barrett, saying that we need to get her in now, in part because she could decide the election. So that brings in a sort of partisan element to the court. So the founding fathers, of course, wanted to have the court removed, but that hasn't always necessarily been the case. And certainly right now, I would say that the court is perhaps as politicized as it has been not necessarily in its entire history, but certainly more than at normal points in history, whatever normal points in history is. And so the court is sort of a red hot cauldron of controversy right now, to put it mildly.
Yeah, first things first. Hey, Frank, that's a good question. Yeah, well, I'll say the obvious, and this is repeated all the time, but here we go. You know, presidential elections matter, senatorial elections matter. At the end of the day, it's the president working with the Senate or in accordance with the Senate that decides the makeup not only of the U.S. Supreme Court, but remember, they're, a president who serves 8 years in office on average will appoint as many as 375 judges. That's an astonishing number. Presidents will leave. They can serve 8 years maximum, well, 10 years technically, but they'll be gone. But the judges they've appointed and have been confirmed will be on the bench for a lifetime. It really is the great legacy of a president in that sense. And no, I agree. And in fact, I thought it was really a good way in which you framed the question, Frank, about the myth, right, of the court. Certainly, and there's, the fact that there are ideological voting blocks on the court shows you that ideology matters in their decisions. It's never been free from politics or partisanship. Sometimes, as Dr. Duggan said, it's worse than others. But we're human beings, and judges and justices are the same way, driven by their own interpretations of the law, their own ideologies, their own biases and prejudices. So, I don't know. It certainly could, with regards to Obamacare, with regards to if the election goes to the courts, that's going to be huge, and the makeup of the court is going to matter. But, the other side of the argument, I guess, is, obviously, if you're on the liberal side of the aisle, you're very concerned right now. If you're on the conservative side of the aisle, everything's just fine, because this is what you have now. And there have been moments in history where the court has tilted farther to the right or farther to the left, and notwithstanding whether or not we decide to pack the court, it's going to be tilted right for a while.
I just want to say something about just because the court makes a decision doesn't mean people follow it. So if the court decides to make a decision that is an unpopular decision, then the American people are going to use the institutions and the power that's available to them to flout the decision of the Supreme Court. And that was one of the reasons why Justice Roberts decided to vote with the majority and allow ACA to take place, because obviously Barack Obama was elected by a overwhelming majority of the American people, and it was passed by the Senate and the House. And so to overturn the will of the American people is a very difficult thing and can cause a lot of problems. And the court is only followed if it's viewed as being legitimate. And oftentimes it is not. I mean, Andrew Jackson basically flouted the Supreme Court decision that the Cherokee tribe, as well as others, could not be moved from Georgia to Oklahoma. And there's some quote, and you know, I'm not a historian, but he said something along the lines of, you don't have an army, right? And the Supreme Court doesn't have an army. What they have is that people view them as being legitimate. And so I think your question, Frank, really gets to the heart of the matter, which is the court needs to be very careful about not getting ahead of their skis. If they start to get ahead of the American people, this could be very dangerous for their legitimacy.
Two things, I agree with all of that. Just two things real quickly. One is, I'm thinking about the Brown versus Board of Education case in 1954. That was a unanimous decision, I believe 8-0. And it basically stipulated that you could no longer have segregation in the schools, and really got rid of the Jim Crow laws. But the Jim Crow laws did not go away in the mid-1950s. It took years, and eventually the Congress had to pass the Civil Rights Act and send in the National Guard to start forcibly doing this. But it took at least 10 years before any of these really were acted, even though the court had ruled. If you ever read Martin Luther King's, Dr. King's letter from a Birmingham jail, which is brilliant if you never have, he talks about in there that all the protests going on are in many ways just, they're actually the ones advocating for the law to actually just be applied, that the court had ruled that segregation was no longer constitutional. And what they were protesting for was not any new laws. It was actually just for them to follow out the law of the land, which was determined by the Supreme Court. So that's one point. And also to the idea of not getting ahead of their skis. For whatever it's worth, we don't elect our presidents, obviously, by popular vote, but popular vote is really the best determination we have for what the will of the population is in many ways. And that would mean now that there's at least 5 judges on the bench that were elected with a president that did not win the popular vote. Actually, I take that back, 4, because one was in Bush's second term when he was popularly elected. But 4 of the judges, if I'm not mistaken, Robertson and the 3 Trump judges were picked by presidents who did not win the popular vote. And so they had started enacting legislation that's deemed by some to be what would be called tyranny of the minority, because the courts are supposed to uphold minority opinion, but you can't, if you try to make the majority always go along with the will of the minority, that can create a whole lot of problems. So I think that there will be a temptation if the Democrats win, that's still a big if, either the White House, both the White House and the Senate, to, as they say, correct some of the misgivings that have happened. But I do agree with Professor Powers as well. Elections have consequences. President Trump did win in 2016. He didn't win the popular vote, but he did win the Electoral College. And while I think Mitch McConnell, Senate Majority Leader McConnell, by not giving a hearing to Merrick Garland, who was seen as being a relatively moderate, reasonable jurist, not even giving him a hearing for an election. He said that he doesn't want to do it in an election year. In that point, it was about 9.5 months out. But then he gave they got her on in less than, what was it been 38 days since Ruth Bader Ginsburg died?
The fastest I've ever seen, yeah. It's
38 days since her death till her getting put on the bench. That level of what is seen, at least by Democrats, and from polling, at least the majority of the public, is just raw hypocrisy. I think that, you know, it incentivizes a further escalation by the Democrats to do something drastic. Whether or not they do that is obviously, some of that's going to depend on how people vote over the next week, and when voting ends on Tuesday.
You know, I'm sorry, I didn't mean to cut you off there. Yeah, we're kind of back to one of the things we keep kind of going back to is what norms should be abided by, and when is it a good time to abandon norms. And it will be interesting to see. I hate the precedents that have been set, to use that term, by how the Senate has first dealt with Obama's nomination and now dealt with Trump's. That's not going to serve us well in the future, number one. And though I understand the desire to pack the court as a means of addressing that, and I know we talked about this a little bit before, but I am a little concerned as to what that's going to lead to. And whether or not now elections are going to be viewed as, okay, whichever party controls Congress will decide, Congress does have that power, decide the size of the Supreme Court in accordance to what best suits their interests. But all these norms that have been broken now, politicizing the court even more, I guess you might say, which I don't think is helpful.
Interestingly enough, I just want to talk a little bit about politics in the court. Is one of the reasons that Biden didn't necessarily say whether he was going to pack the court or not was because a third of Americans are the only ones that can name the three branches of government. So when you talk to your average American, they just say the government does this and the government does that. They don't understand the distinction between, the Supreme Court, the legislative branch, and the executive branch. And so they don't really know what pack the court means. They just know that if their health insurance is taken away, they want something done about it. And so that's why Biden didn't want to come forward and say, I'm going to pack the court, because the American public will potentially change their opinion on court packing based on whether they have health insurance or not, right? And based on some of the decisions that are going to be made. So it was kind of there was no benefit to saying that I wasn't going to pack the court or that I will pack the court until, the decision comes down from, and the people are going to see it as the decision of the government. They're not going to necessarily see it as the decision of the Supreme Court. They're going to be like, well, why is this happening? Oh, well, the government took our health insurance away.
Well, as you noted, the court is in part restrained by public opinion, by how well the public will accept or reject their decisions. And, the court, Chief Justice Roberts, that's an excellent example. I have no doubt in my mind he cast his fifth and deciding vote to uphold the Affordable Health Care Act because he knew that it would threaten the court. And certainly its position, again, perhaps more myth than reality of being the subjective body. So I think the reason that Biden, won't, I agree with what you said, but I think he's just going to wait and see. He's going to count on that. I think a lot of Democrats now are counting on that the court won't overturn the healthcare law, the ACA. Interestingly, we haven't talked about judicial activism or judicial restraint, but here's where we find, I find it very interesting. Typically, judicial activism is favored by liberals. Judicial restraint is favored by conservatives, and this is one of those instances where the sides now have flipped. Right? Where that's why there really isn't activism and restraint. There's conservative activism and there's conservative restraint, and there's liberal activism and there's liberal restraint. And this is one of those instances where liberals are hoping for restraint and conservatives are hoping for activism, and that the court will strike down a law passed by elected officials. So, a lot of hypocrisy to go around everywhere, I guess you could say.
I just want to add to that. Going back to Biden, I think that there's also a political calculation. He realizes that there is a subset of the population that might not be in favor of packing the court, but at the same time is planning on voting for him, and he doesn't want to turn any of those voters off. There may be some people who are in the center right that want a more conservative court and are voting for Biden. And if he comes out and says, I'm just going to pack the court with more liberal judges, they may hold their noses. They don't like Donald Trump, but they may hold their noses and vote for Trump for that reason. So I think part of it is just simply he doesn't want to turn those voters off, because truthfully, if Biden doesn't win and or the Democrats don't win the Senate, this is all a completely moot point. Biden could win, and if he doesn't have the majority on the Senate, he can't do this anyway. And you know, I should point out, Professor Powers, you said correctly. I think the number was 330 judges that a president normally picks.
In some cases, it's as high as 370, 375, or something like that.
Right. But Trump has already picked 220. I just looked it up. And one of the reasons for that is when Mitch McConnell when the Republicans controlled the Senate, Mitch McConnell said, I'm not going to give a hearing to most of President Obama's appointees. So the last 2 years of Obama, he didn't really get very many, if any, judges through. I'm sure he got a few, but it wasn't very many. And what ended up happening was when Trump came in, there were just dozens and dozens of openings that normally would have been filled by Obama that were not. And so that is also seen as being, again, an escalation of this kind of almost, I call it parliamentary warfare, because I keep saying that I think we have a lot of the disadvantages of a parliamentary system now without any of the advantages.
Well, for good reason or not. Yeah, for good reason or not, to piggyback on your point, the Democrats got rid of the filibuster.
No, absolutely.
And again, I think this is why we really need to stop and think. Momentarily, this might benefit us, but it ended up hurting the Democrats considerably. Part of the reason Trump was able to get 200 some odd judges appointed is not just because there were vacancies, but because the Democrats could no longer use the filibuster to stop it. And so
that wouldn't have mattered for this, because you had a Democrat appoint. It would have been different if it was a Republican appointing it in the Democratic Senate, right? But you had a Democrat. It wasn't that they couldn't get 50 votes. The problem, or even 60 votes, is that they couldn't get a hearing, but they controlled the Senate.
So but
it's easier to get them passed through.
Right.
Well,
so
sure.
I just want to draw this analogy, and I'm probably making it worse, and this is a terrible analogy to use, but I'm just going to do it anyway. Which is that having lived in the Middle East, it's like the Israelis never just attack the Palestinians like without having something happen before. They're always retaliating against a former decision, and the Palestinians never outright attack, you know, without provocation. It's like there's this tit for tat in Israel, you know, where the Palestinians are always retaliating. And the same thing is now happening with judges, is that one of the reasons why they got rid of the filibuster is the Republicans were just blocking all of the, you know, appointments. And even before they were blocking them, of course, the Democrats were viewed as being aggressive with Justice Thomas and Justice Bork. So there's kind of both the Democrats and the Republicans have this sort of long memory of all of the injustices that were done in the past. And every single time when they break a norm, they say, we're not really breaking the norm. It was those guys that did it.
Right. We have to do it. Yeah.
We have to do it because of what you did with Bork or Thomas or Kavanaugh or, you know, and there's always sort of a justification for breaking a norm.
I agree with that. And what I keep saying over and over again is if the Democrats pack the court, the Republicans are just going to do it again when they get power again. And they will eventually have power again. Again, this is assuming they lose it. I mean, we could be sitting here in a week with a Republican Senate and a Republican president. And this is all, we're going to all look really silly for even entertaining this discussion. And that is a possibility. So, you know, we have to keep that in mind as well. But, you know, I think that we're going to continue to see this continued escalation. I think that this is just the nature of where we are, and you know, so much of. Well, I'll leave it at that. Yeah,
just to go back to what Frank said earlier about, you know, is the court really outside of, you know, partisan politics? It's just like if masks are a partisan issue now, then everything is political.
Everything is politicized now. Yeah.
Which is really unfortunate because that diminishes the legitimacy of all of the institutions, because everything is seen as being sort of a partisan issue rather than being for the best interest of the country.
Yeah, I'm gonna steal from Dr. Kupfer here. He's the one who first used the analogy. I thought it was a really good one. Everybody's wearing jerseys now. It really doesn't matter. You know, everybody makes their decision based on the team they're on, and unfortunately not necessarily for, as you said, Dr. Duggan, what's in the best interest of the country. So.
Yeah, I agree with that. Well, I guess you're mentioning me, so I guess I agree with myself.
I stole it from you. Yeah.
Since we're being recorded, I want to get everyone on the record here. Let's just put the pressure on. Do either of you think that, and I'll give my answer if you're interested in it as well, but do either of you think that that Biden and the Democrats are going to win the Senate and the White House and pack the court? Or do you think this will all be moot, or that they will and then they won't do that?
I think
So
they're going to win.
I'll go out.
Okay, go ahead. Go ahead.
I definitely think that there's a very good chance that, I would say there's a 50-50 chance that the Democrats will win both the presidency and the Senate. I think that Biden most likely will win if everything remains constant and if all of the pollsters are not, like, you know, I don't know, wrong, which is a possibility. They could all be wrong except for a few Republican pollsters. That's a possibility, but the Senate's going to be harder to take. But the scenario of packing the courts is not outside of the realm of possibility, because not only do we have the decision that is going to be made about ACA, but also abortion as well. And we've seen young people going out onto the streets and demanding their rights. And if young people believe that their rights have been taken away by the court, they're going to force Biden's hand on this one. Let me just say that outright. If you take away the right of abortion in many of the states, now they're not going to take away it in all of the states, but if they take it away in you know, and curtail it in Florida and in a lot of the red states where they have Republican legislatures, and they get rid of 20 million people's health insurance, Biden can't ignore his base, and he will pack the court.
Although it's going to be interesting, because if that happens, then I mean, you still have to bring a case to the court. The court can't just suddenly say we're reinstituting abortion rights or you know, the ACA. You would have to have you'd have to go through the whole process again. I'm sorry, Professor Powers, you were.
No, that's okay. That's all right. I think Biden's going to win. If pressed to put my child's college fund on the line, I would expect that the Democrats will win a slim majority in the Senate. It'll be really weird and bizarre if we end up with a 50-50 split in the Senate, but it's not beyond the realm of possibility. Not to tip my ideology or anything, but I have to, maybe I'm trusting the better nature of people, but I think particularly with Justice Roberts being the Chief Justice, I think he's going to work very hard to try to make certain that the court does not overturn completely. They may overturn parts of it, and in fact, that's what they did last time, the Affordable Health Care Act, and I will be shocked. I was going to say shocked if the court just outright overturns Roe v. Wade. I'll be shocked.
They'll chip away at it. I'm not saying they're going to overturn.
Well, it's already been chipped away. I mean, that's already been done. But if you recall, though, I mean, Roe v. Wade set up a system where states are free to regulate abortion. It only protects for the first trimester. After that, states have more power to insert regulations over the practice. So, you know, a lot of people, I think, don't really understand, and understandably so. There have been numerous Supreme Court decisions. Different states do different things, some blatantly unconstitutional and others. But if we're talking about whether or not the court's going to reach a decision which would essentially return the decision as to whether or not abortion is legal to the states, that would require overturning Roe v. Wade. I don't think they'll do that. But that, again, I think it'll be as much as anything out of self-preservation for the very reasons you pointed out. The court has no enforcement mechanism. It is only powerful because we allow it to be powerful. And we allow it to be powerful because it doesn't go beyond the bounds of acceptability. And I know there's still a strong contingent of Americans who think Roe v. Wade was the wrong decision to begin with. And I can respect that. But, you know, that was a long time ago. I think it's become accepted precedent. And whether you like it or whether you don't, you know, this is one of those precedents I think the court would be endangering itself in returning it. So that's my prediction. I think the court, to preserve itself, ironically, so that it doesn't get packed, right? I think it's going to weigh very heavily on the decisions they reach. I think they know the court will get packed if they do otherwise. That's what I think. So,
I'm going to be wishy-washy. I agree with both of you. I think that somewhere in the middle is probably where it's going to happen. But my guess is, if I agree with you, Professor Powers, if you maybe put my kid's college fund on it, I would guess that Biden's going to win and that the Democrats will have, you know, somewhere between 50 and 52 seat majority. I don't think it'll go much higher than 52. I mean, if it's a wave of massive proportions, maybe 53. But you know, we got to remember the Democrats are going to lose a seat in Alabama. That's probably the most certain outcome of any of these races. So they're starting already from a bigger deficit than it might even look like on paper. But my guess is, so as we talked about on Monday, if the Democrats win, they're going to put their capital on making Puerto Rico and Washington, D.C. states. That would give them 4 almost guaranteed Democratic senators, and that would help reform the bench from their perspective for a long time, because it'll make it much, much more difficult for the Republicans to ever get a Senate majority again. I mean, they can, but even when they did, it would be very slim, you know, 50, 49. It would just make it much more difficult for them to get back to a majority. So my guess is that that's probably more of the direction they would go in. And I think that would be more palatable to the public as well. Because most of the public, at least, I agree with you, Professor Duggan. I mean, most people don't know how any of this works anyway. But when you do ask the question, are you in favor of packing the court? Now, I should also point out the question, when you ask people, are you in favor of reforming the court, you get a lot more support, right? You're basically saying the same thing 2 different ways. So a lot of it is, how do you interpret those questions when you're a respondent to a poll, which I think matters a lot too. But that would be my guess. I have a hard time thinking that Joe Biden, who's such a creature of the Senate, is going to pack the court. But I could be wrong. I could definitely be wrong.
I think in the long term for the country, it would be a mistake.
Right.
I'm hoping it doesn't go there. And that's not to lay blame on the Democrats. I have no doubt in my mind the Republicans would be saying the same thing if they were in a similar position. But I'm hoping it doesn't go there. I just can't see how this is going to end well if we do.
What's interesting about there is this tension between democracy and Republican, or, you know, the idea of a republic, because right now, the Senate is really not representative of the American people as a whole. And it's not supposed to be. It's supposed to represent the states. But there were millions more votes for Democrats in the Senate elections than the Republicans. And yet the Republicans actually gained seats in the 2018 election. And so the Republicans need to be very careful about thwarting the majority of the American people, because they're in a position to do that. I mean, let's say hypothetically Trump does win another term without a majority of the American people. That means that he would have a majority in the presidency, perhaps a majority in the Senate, and then a 6-3 majority in the Supreme Court.
Right.
All in power without a majority of the American people. That's very dangerous to the legitimacy of the government.
I mean, there's a very real possibility. I'm not saying this will happen, but there's a reasonable chance, enough that it's worth actually discussing out loud, that President Trump could lose the popular vote by as much as 5 million votes this time and still win the presidency. Right? That's very plausible. That kind of feeds to your point. You know, I also wanted to just add, I looked up earlier the average life expectancy at the time of the founding in 1776, according to the Google, so take it for what it's worth. But this is what I found. I haven't done extensive research on this, but according to the Google, it was 38. Now the same article said for people who lived to be 60, they tended to get to 75. I don't know. Like we were in the middle of doing this, I didn't want to start reading too much about it. But if you take that number 38, and that was for a male, I'm sorry, but those are the only people getting appointed to the court back then. But if you take that into consideration, if people were only living into their late, 30s, early 40s, a lifetime appointment was very different than it is now. I mean, I keep telling my students, Justice Barrett, she's 48 years old. If she lives to be the same age that Ruth Bader Ginsburg is, I told them, you're going to be, if you're 20 now, you're going to be preparing for retirement when she goes off the bench, potentially, right? And you're still in your freshman or sophomore year of college. She's going to be around for most of your adult life on the bench. And I think that one thing that we might see is really an attempt to amend the Constitution to add some type of term limits on judges, whether it's 12 years, 18 years, so that you don't have this kind of almost situation where one side or the other feels like it's a catastrophe and that they have no hope of ever participating in a democratic process because of these permanent lifetime appointments. I wouldn't be surprised if that's something that more of a palatable direction that we go into. And I don't have much faith that you could ever really amend the Constitution at this point, but maybe I'm wrong about that. I hope I am, because I think that would probably make a lot more sense than trying to pack the court, in my view.
It's interesting. That just hit me, and maybe I'm overreacting by saying this, but I think we run the risk maybe here too of a bit overreacting as well. I think if the court overturned Roe v. Wade, that would be huge. That's been established law. Precedent was set for that. Because of the Affordable Health Care Act, and don't get me wrong, I would keep certainly parts of the act if it were my dithers, certainly pre-existing conditions and things like that. And I think we're better off as a country when everybody's covered rather than not. But at the same time, this has only been around for just over a decade. It's not as if it's some established liberty or right that if we lost it, the country should rise up in riotous outrage. I think we have a tendency in our time to think that any loss by our side of any sort amounts to a tragedy. So I kind of keep these things in perspective, and again, it depends on which side of the aisle you sit. There's a large number of people in this country that would be happy with the Affordable Health Care Act being overturned, and so we run the risk, I think, of seeing things through our own prism, I guess, of what would be good for the country, what would, in particular, and I'm guilty of this as much as anybody, as to what would be a tragedy per se. We lived without the ACA, before 2010. I'm not saying we'd be better off without it, but I wouldn't call it a tragedy per se. I think we're going to move in that direction regardless. It would be a setback, but I don't think it would be the end of it. But to the extent that it would mobilize people, if you're in favor of it, that would mobilize people to become more active, it would just make more certain that in the future, something equivalent or perhaps better would be adopted. But
well, I think what would happen was, without getting too sidetracked, and since I know we're over time, but I mean, what would end up happening, in my view, is if the Democrats control the Senate and obviously the House of Representatives, I think that would give them incentive to just say, well, fine, it's constitutional. We'll just do Medicare for all. There's no reason why that's not constitutional.
Or follow the guidelines of the court, pass something that, because the court's going to explain why it's unconstitutional. And if they were to strike it down, and you're right, if you've got the numbers, you can repass it, and this time pass it in a manner that will pass constitutional scrutiny, assuming they just don't gut it to the point that you can't. But no, you're right. There are alternatives that Congress could take. Yeah.
I think so too.
Well, I actually have to go vote.
You go, man.
I did yesterday. Well, I dropped off my ballot, and I keep checking all day to see if it's been counted yet, but it hasn't. I did a mail
My
ballot.
son, this is his first election, so this is the one thing as a family, we're going to risk our health. I don't want him to do it by mail. I want him to do it in person. So we're going
Yeah, I get
to mask up and I was telling my wife, she was like, should we do it? And it is, but I want to take pictures of him doing it. I want it to be something special. We got him a mask that says vote. We even got him a special mask for the occasion. So I'm waiting till Tuesday. Yeah, I'm gonna do it then.
I went twice last week to try to vote, and I waited in line for like 20 minutes, and it wasn't moving, and I'm just like, this is crazy.
Wow.
I got home on Friday. I requested a mail ballot. I went over to the library yesterday. As soon as it came, I filled it out and dropped it off. They have boxes there. But I get that. If it was my kid's first time voting, I would do the same thing.
Yeah.
It's easy for me to say. Hopefully, there won't be a pandemic when my kids vote in 8 years.
Hopefully, there'll still be a republic by the time.
Oh God!
I'm sorry. Here I am talking about being all tragedy, and I throw that in there.
It's all right.
Was it ever really a republic?
What's that?
That's a joke. Nothing. That was just that joke.
Oh, yeah.
Well, I want to thank you all once again for your time, for sharing your knowledge about the branches of government with the students. Like you heard the professor say, if you haven't voted or you're waiting till November 3rd, that's fine. But if you have the opportunity to early vote, go ahead and get out there and early vote. Let's make a change, regardless of which party or affiliate you're voting for. This is your civic duty. Exercise your right. Thank you all once again for joining us, students.
Thank you for hosting this, Charles. Appreciate it.
No, thank you.
Yeah, thank you.
No problem. And so this will be recorded, and we will post it on our Student Life YouTube page, and we'll share it with the political science faculty and as well as all faculty, so they could share it as a component of their course if they want to, or they want to add it to a catalog of videos that have been done in the past. So look out for that to come before the end of the semester. So thank you once again, gentlemen.
Thank you. Thank you all.
Thank you,
All
sir.
stay safe and have a great rest of this fall semester.
You too.
Thank you, gentlemen.
You do the same.
Okay. Good luck voting, Ted.
Thanks.
Yeah, good luck.
Yeah.